one
One link.
one link for everything. So what's gonna happen is that link's gonna grow as the class grows. So I have the link now, so if you send me an email, I can just turn around and send you the most current one. But it's not gonna just show you one night, it's gonna show all of them. Which makes more sense. Because as you can see, they're identified by dates. So you can look back, you've got your dates, so.
I sent it in,
You did? Okay.
I did also, but 2 weeks ago, when they lost that. So it's okay, if you're gonna send everything, it's okay.
You have to tell me to do it, I won't do it automatically.
Oh, I did send you an email.
Okay.
asking you-
I believe you. But I don't know that I have it, so just send it to me again.
Maybe, to be honest, I didn't check that, I didn't, told you I didn't check.
So like I said, just send me. It's just easier that way, to just send them away. Then you've got everything up to date. Now, if anybody got one today, you won't have tonight. Which means I'm gonna be doing 20 to 30 of these a day, I can just see it now. All right, 114. Now, this 114 is about rental lists. Is the 1 week ago important? They purchased, it says the woman purchased the list a week ago. Is that week ago important?
Yes,
Why?
because it could be irrelevant of what's currently on that list.
Now, you only have 30 days to come back to get a refund. So is that knowing, they gotta stick that in the question somewhere, because I've gotta know if I'm less than 30 days or more than 30 days. Because if I'm more than 30 days, I've lost my rights.
That's something that's- I don't know if that's the essence of the question. I think the essence of the question is
Well, it is part,
part of it, but
Yes.
it's not the whole.
now, well, what the decision now is it 75% or is it 100? See, once I know I'm within the 30 days, which the first sentence told me, now the issue is it 75% or 100%? In this case,
100%.
why?
Because it was
Well,
on the
Because the information was incorrect.
Yeah.
That's part of the reason that business is with. Because trying to keep those lists current is darn near impossible.
Yeah.
But that's why those companies still exist. But they're not doing a brokerage activity. They're doing marketing. They create those apartment books you see by getting people to advertise it. That's how they create them and distribute them and make money. Back when I first came down here, they actually, sold you a list. As a consumer. Now you can get apartment books, dozens or realtor.
get it online with rental leases.
Yeah. Well, we know today that just about anything you want is online someplace. It's just a question of budget.
So the answer is D?
See. All right, did you say 8?
8.
8 says that the license is issued to only one active broker of the real estate broker corporation becomes void for any reason. Another broker must be appointed within 14 days. Failure to appoint another active or temporary broker will result in the action taken against the corporation's registration, which is?
C.
Cancellation.
What's the answer?
C.
B?
Answer is A. A.
A. Okay.
It would be automatic, right?
Yes.
Now, they're not talking about the associate's license. They're only talking about the company's license.
Right.
You become involuntarily inactive until you find yourself another broker. Okay? And the next one?
Yes,
What's
it's
the
not
next
number
one?
9.
12?
What's your next one?
12?
12. Oh, you got a question on 9?
And 19.
All right,
Will
9?
become-
Okay.
On
I'm
page
just
one.
trying to go in order, basically. All right, number 9, a sales associate employs an unlicensed personal assistant to help with real estate property management. The unlicensed assistant may not, it says collect rent payment from the tenants. See what you do that. Deposit rent monies in the bank, place for sale signs on property, show a rental property to a potential tenant.
D.
D.
Hey. I can play chauffeur and drive them to the property and allow them to enter, but I cannot show it to them. Show it to them isn't standing at the door and letting them walk around. Show it to them is walking through the house with them, explaining the house, amenities, community, whatever it may be. All right, what's the next one? Did you have 11?
No.
What do you have?
12.
12? Okay. All right, number 12.
But,
Which,
yeah, could you explain 11?
okay, one difference between a general partner and a limited partner is only a general partner may be registered as a real estate broker. Limited partners must make a cash or property investment. While both have general partners, the most, there must be 2 or more general partners. What's wrong with that answer?
You only need one.
Yeah, one. You need one on each side, one general, one limited. It only takes 2 people to make it. Then limited partners must be licensed as either active or interactive sales associates. That don't make any sense. Because we know limited partners focus on investing. They don't get involved in the operation because they only want to be liable for what they've invested. They get involved in the operation of the business, they now have jacked up their responsibilities. So the answer to that question was?
B.
B. Well,
Yeah.
okay. It says which business entity may register as a real estate broker? Well, we know Corporation Sole is a church or an ecclesiastical organization. They cannot be registered as a real estate broker. A cooperative association cannot be registered. Limited partnerships,
Yeah.
Yeah.
business trust.
No.
There's 2 lists. 3 of them are on the cannot register as a broker. The other 3 can buy and sell real estate. But that's not what this question is asking. See, now, think about this. If you thought they were asking about buying and selling real estate, you don't have an answer. Why? Because all 4 of them can buy and sell. So you would not have, if you thought they were talking about these business entities registered to buy and sell real estate, you don't have an answer. You need all the above. And I don't think that works since we already have 4 answers. Okay? 19?
Yeah, 19.
Okay.
14.
Oh.
Okay, 14. A licensed real estate broker and an attorney who specializes in contract law form a joint venture for the purpose of locating and selling to investors raw land that is suitable for commercial development, which statement is true. The attorney is exempt from registration to hold a broker's license because she is an attorney.
No.
That's false. They have formed an illegal ostensible partnership. Nothing in there indicated that they're not paying, not doing what they're supposed to. Because they are performing real estate services for compensation, both must be licensed as real estate brokers.
Yes.
Okay, and then it says a joint venture is not required to register with DBEPR. Therefore, there is no need for both partners to hold a real estate license. That's false. Because it's true that the joint venture doesn't have to register. Because the two brokers are already brokers. So the two people in the joint venture are already registered as brokers. So we don't need to go any farther. Next one's 19.
Wait a minute, I think I missed that.
See.
Okay, I got that, but.
It says, which statement is false concerning the payment of an unearned fee or kickback?
Which one is that one?
19.
19. A real estate licensee may be paid a fee for referring buyers to a title company.
No. What's
That is illegal.
that?
Real estate licensee may share part of the commission with the buyer or seller in a real estate transaction.
Yes.
Why?
Yeah, they can keep the commission if they want. You can donate your part of commission if you want to the buyer.
Why?
They're the direct parties involved in the transaction, so.
If they
Okay.
wanna do it, they can do it.
They are parties to the transaction. But why can they do that?
Because they have a license.
If they are
They don't have a license.
No?
Mm.
As part of the closing cost?
Because of the conflict of interest.
Because rule number 61J210.025, paragraph 2 of the rules of the Florida Real Estate Commission.
Really?
Really? You know I don't bullshit up there.
No, that would have been a good one.
How do I know that? Because you don't know how many times in the last 40 years I've been asked that question. It used to be the law came in a little blue book about that big. And I had the first time it ever happened, I had an ex-student who was now out selling real estate, and he ran into a problem. He was going to give his commission to his daughter, who he was helping buy a home. And the other broker said, no, you cannot do that. She does not have a license. And they went back and forth and back and forth. And he called me, he says, I know that you'll know the answer to this. I said, yeah, and what I did is I went to the copier and copied that page. And then faxed it to him. I told you, I've been doing this. I hate fax machines. And I told him what he should do with it. And he did. And it shut up that person who doesn't know what they're talking about. But I say to you all the time, when something's based upon the law, that should always be the beginning of your conversation with somebody about it. Because guess what? That ends the conversation right there.
No arguments.
They can argue, but it's black and white.
No arguments.
All right, moving on here. A real estate licensee may also be licensed as a mortgage or loan originator to legally be paid for referring. It's true. Then it says payment of kickback must not violate precedent. That's true. So which one's false? Right. So I eliminate everything that's true, and that was B, C, and D. And if B, C, and D are all true, then I guess, A has to be false. Okay. Okay? I find it very interesting. You guys do not have a handle on chapter 5. This is the first chapter that I've had that many questions. So a little suggestion that maybe you need to stick your nose into chapter 5 a little bit. Because I try to watch for that. When I see one chapter get that many questions being asked, there's an issue there. I think maybe you would shell shock from chapter 4, which was the agency, the brokerages, when we got to 5. It's just a lot of information, but it's cold hard facts.
Is the sign-in sheet going around?
Yeah, it should be.
Unit 7, page number 163.
163, please.
And number 5. I
I have to get this. Start that one. Question 5?
Yeah.
We're on page 163. We're in on question number 5.
I still do not grasp the surety bond. I mean,
Surety bond is something that landlord would post that would allow him to use the escrow money. And you have, and it says in law that they have to pay the tenant 5% interest.
Yes, I understand that, but is, when, I mean, in this question, and I didn't understand because this is when you have more than 5 units, right?
Yeah. It says here, when security deposits or advance rents are required by a landlord in Florida, such funds, it says, must always be kept in a separate account, may be deposited in the landlord's account of, if sufficient surety bond has been posted, must always be placed in an interest-bearing account.
That's not true.
and this is not true as well.
And I know that D is wrong, because 7% is not a number that was used.
Well, so, that was A or B.
C is also false,
A.
and B is also false.
B.
I know,
The landlord's account. He's supposed to have an account.
Now, if you're telling me that answer B is the correct answer, I'm sorry, yes, B is the correct answer, then A can't be,
no,
because they contradicted each other.
yeah.
Are you ready? You have no idea how to answer that question. Tell me what the answer is.
A.
B, because it says may and the other three say must.
The may and the must.
Oh, then we go to,
May, right.
That's number 2.
that's it.
I forgot about that.
See, none of those options that they have, they're not mandatory. The landlord can pick which one they want to use. So to say they must, the only thing they must do is have it in Florida. But they can have it in their own personal account in Florida if they posted the bond. If they didn't post the bond, they need to put it in a separate account.
But it has to be in the name of the landlord anyway.
Yes.
All right, let's go back to chapter page 171. At the bottom of 171 is the chart that you drew, that I drew on the board. What's missing there are the joint tendencies, the tendency commons, the tendency vitality. That's part of it. Now, the next few pages, probably about 4 or 5, address what we did on board. So let's do this. On 172, I'd like you to put a bracket starting with line 1 where it says freehold estates and go down to line 39. And on line 10, put a star beside of a life estate. You don't have to have too much on it. Here's a life estate for a definite period of time.
Yes.
Yeah, for the person's life.
Person's life.
Yeah, the person's life.
No.
No.
Ah,
No.
no.
It's not.
No.
Yeah, it's for the life.
In order to be for a definite period of time, the document has to show when it will expire.
Yeah, exactly.
I don't know about you, somebody hands me a deed that's a life estate and has my death date on it. I'm not so sure that, I'm interested in taking that death document. Yes, ma'am.
It would make sense that the life estate comes to the life of that person,
Yes.
but that, okay, sometimes they're trick questions, okay.
Well, let me ask you a question. Does anybody in this room know when you're gonna die?
No clue.
Okay. And life estates are not for a definite period of time. A definite period of time means, in black and white on a piece of paper, there has to be an expiration date. And the only one that does that is the estate for years, which is written leases. We did this the other night, so. That was that night. What's the difference, when you talk about a life estate, what's the difference between a remainder estate and a reversion estate?
Taking it back.
Under
to the same-
the goes back to the government after that.
Yes.
The remainder goes to an heir and the
Yeah.
other one goes to a designee.
Goes back to the estate.
That's
It
it.
does not go to an heir in reversion. It goes back to the estate.
The state.
Doesn't matter if the estate holder who created the life estate is dead. The estate is not. And a life estate is when a life tenant dies, their estate is gone. They can't dictate what happens to it. Only the fee simple owner that created it to start with can do that. So that's why they talk about remainderment. First, we're on page 172. At the bottom of the page, line 40 through line 18 on the next page talks about homestead. Homestead is very unique in Florida compared to most places, so I'd like you to put a bracket around that. Take a couple minutes to read through it. It starts down at the bottom of the page and runs through line 18 on the next.
What story is that in? Save our own.
That's why you're not signing.
He's got the attendance. No. Anybody else? What's a homestead?
A piece of property.
It's what? Primary residence.
Yeah.
How many of those can you have?
One.
Why would it be advantageous to have it in Florida?
Because of the taxes. Well, it's more than taxes, it's a whole protection process that goes with it.
And if you die, your spouse,
Well, I'm dead, I don't really care.
but the kids.
The amount of exemption compared to other states.
Forget the exemption. That's not the benefit of this homestead.
The protection.
We'll talk about the homestead
Protection
exemption,
against
tax
liens.
exemption. That's not the real, that's not the benefit. The benefit is,
To protect the
you go to a
family.
hospital here, and you walk out with a $200,000 bill,
Yes.
They can't pay
you
your
can't touch your homestead. Now, if you sell it, they can go after the proceeds, but they can't touch your homestead. That's not true in most places.
And for foreclosures?
No, here's the way to remember it. A homestead can implode. It cannot be, no, I'm sorry. Yeah, cannot implode. It can implode, but it cannot be attacked from the outside. In other words, if you don't make your mortgage payment, you don't pay your property taxes, it doesn't matter what the property is, it's gonna be bye-bye.
Yeah.
But when you talk about debts outside of the homestead can't be crushed from the outside.
But,
Do me a favor, don't get ahead of me.
yeah,
What you're looking at right now is ahead of me.
maybe. So, when you sell the house, then you go after the money you collect from selling the house?
Yes.
So it's the same thing then?
No,
No,
because
if I never sell the house and I remain as my primary residency, they can't touch it.
Exactly.
Why do you think all these crooks and other persons
Everybody
have
comes to
homes in Florida? And they pay cash for them? I won't mention any names, I think we all know who I'm
Yeah.
I have a question. It says in here that the spouse has to sign for the homestead whether she.
I'll get to that.
Okay,
Good question.
You know where I'm going.
Yes,
okay, if the person, is not on the deed, on,
how about let me explain it? Do me a favor, don't look at the books. That's why I have you close your book.
right?
Because if I don't explain it first and you start reading it, there's no explanation for what you're reading, and you can get confused real quick. Now, here's the deal. With the homestead, there are several different benefits. One is the tax deduction that you have up to $50,000 on your homestead. That's one. The other we talked about, debts from the outside cannot collapse in. Yes.
that tax deduction,
We'll talk about that in chapter 18,
okay.
because there's a whole section on it. I'm not gonna, there's a few notes here that makes more sense. Now, as a married person with kids or without, I can buy my homestead, I can buy any property in my own name. However, what if you had this situation? I own my homestead, in my own name. I have a wife and 2 kids and a secretary.
I know what?
Secretary. You're also assuming that she's female.
No assumption.
I just did that. Nah, never mind. Everybody gets a fair turn. In my will, I leave the homestead to my secretary. My property. I can do whatever I want to.
She said that
Does
is
the-
secretary.
Now you made me forget my question.
That is a good secretary.
So
Alright.
you leave it to the
Yeah,
secretary.
I'm kind of back, don't talk, or I'll forget it again.
So
The
if it's.
question is this, since it is my property, it's in my own name, I have the right to do whatever I want to with it. However, the laws in the state of Florida, called the Homestead Act, protects the wife, or, the spouse and children.
I'm sorry.
So, continue, please. Protect the spouse and them, it's my case, so continue, please.
Now, if I was a real estate agent, what would I say to him? No, sir, I'm serious. What would you say to him if he asked you that question? Doesn't matter what the question is, it was a legal question. What do? You consult your attorney and you keep your mouth shut. Even if you think you know the answer. Because if you're that much off, you're that much dead. The homestead protects the spouse and the children from the improvidence of the breadwinner. Now, when I first started teaching, it was husband, wife, and kids. And the wording was different than it is. Because when that law was created, females weren't allowed to own property. They were possessions.
What year was that? Chattel.
Probably 1800s, early 1900s. Well, think about it, women, when did you get the right to vote? Not the same time men did. So there's a lot of other shit that went with that. And you've been making up for it ever since.
Yes, sir.
Turned tigers. Real smart. All right. Let's say that, now, what if I had a will that said it was left to the secretary?
It doesn't
No,
matter.
it doesn't matter.
Okay.
Your wife is still protected, correct?
Now,
Spouse is protected.
let's assume that I die without a will, intestate. What happens?
Goes to
It's part
the
of the
spouse
So
and.
it's part of the- doesn't matter.
Still goes to the spouse.
Doesn't matter.
Goes to this.
First one.
Now, what type of estate does the spouse get?
Life estate.
Life estate. The kids are
Remainder man.
remainder. Put that damn pen down.
Now, what happens if it's not a spouse and just?
How about waiting till I get through? We're changing the rules tonight. You talk once I'm finished. Not wild. Because I have to set it up first before you can start asking questions about it. You can't ask any questions about it until you know what you're talking about. The kids are vested remainder in fee simple. Which means they're the real owners of the property. Because mom needed to sell that property, kids are 12 and 13, she's got a major problem. Because they have to be on the contract and sign on the deed, and they're not legally allowed to at that
Unless
age.
there's the early bird.
Which means the courts will probably appoint someone to watch out for the affairs of the kids, so you'll wind up having to get a legal representative to protect yourself from your own kids.
That is awesome. I like that one.
I always find this discussion raises most people's blood pressure. Now, explain to me why the kids have more rights than spouses.
Because if she remarries.
No,
Direct,
nothing to do with that.
directly is. Directly is.
Right. They are blood. She is not.
Oh.
Because part of each spouse is in that little one.
Mhm.
So there's more of the other spouse, the dead spouse, than the kid.
And there is a family.
Moms are just vehicles.
What is the children about?
Both the children were adopted. I would get myself an attorney. Because you got a mess. How about this? I got even better. She said, what if the kids are adopted? They probably still take precedence.
They're treated just like a natural born child.
Yeah. How about this? His, hers, and ours.
They all belong to
His, hers, and ours.
No, everything
Well,
belongs
only
to
the
them.
hours.
Now we got a real mess. Which tells you what, if you were about to try to take a listing on that property, they need to talk to their attorney.
Yeah.
Why? You gotta figure out how this property's gonna be disposed.
Yeah.
It's not, obviously cut and dry.
Florida,
And I
Dale,
thought that one of the parents died, the both parents are still alive, it's automatically legal.
If it's a tenancy by the entireties. Meaning,
married.
not married,
joint-
that they are married and both owners. Just because that you're married doesn't automatically mean when you buy a piece of property in Florida, you're a part owner. Whoever's on that deed is the owner. If there's only one spouse on that deed, they're the owner. Now, but the other spouse has protections under the law when it comes to homestead.
So that's not supersede the other one? I mean,
Supersede what other one?
And entireties, supersedes homestead?
It doesn't subside because in tenancy by the entireties, they are automatically one. So when one dies, it automatically goes to the other.
Even though they're homestead?
Homestead doesn't have any bearing on that.
But they need to.
See, but homestead still has advantages. Just the one about the spouse becoming a life estate holder and the kids' vested arrangement, that won't happen if you both already own it. The scenario I gave you, I see it, give me a second.
It's both in the deed.
If they're both in the deed, we don't have the problem. It's when one of the spouses own it that we've got that potential issue that we just described. Put them in tenancy by the entireties, and one dies, certificate of death is all I need for the other one to sell it. Yes,
What about if the spouse that doesn't own the home does not sign the documents?
sign what document?
Right here, it says, contract, mortgage, and deed. Has to be
Okay,
signed by
right.
him.
Then you don't sell it.
You don't sell it?
That's right.
But-
Because I wouldn't buy
I
it.
have to agree.
I wouldn't buy it because if you didn't sign on that, even though you weren't an owner, it was a homestead, you still have rights. Yes,
I understand that the wife needs to sign for the homestead, even if she's not on the mortgage.
deed.
On the deed.
Okay. But what if you got married afterwards,
Yes.
Still
and then
wife.
decided you were gonna get homestead?
Then you still, you can have homestead without a spouse.
No, but if.
I know, but now you've gotten married,
Mm-hmm.
and
That was
you
a
haven't
mistake.
filed yet for homestead, and then you go ahead and you file for you wanna file for homestead. But she wasn't there to be on the deed.
So in other words, you
beginning.
haven't been getting the tax benefit?
Right. You
buy
just
it
bought the house.
Before you marry,
You just
Okay.
bought the house, you're not married, you get married
after the
2
5
weeks later,
Okay.
and then you wanna file for homestead. Do you have to bring her in, or do you have to redo the deed?
Is she on the deed?
No, she's not,
Because
because,
she doesn't have to be there.
And she can do home.
But
See,
now
here's
she's
the-
your wife.
Here's the rule of thumb. It takes one spouse to buy, it takes two to sell. So going in, that spouse that's not an owner doesn't cause a problem. It's when you turn around now and you want to sell it, because it's the homestead, because if it was this building and one of you owned it, doesn't matter.
So what you're saying is, if the wife isn't put on the deed, or she doesn't sign the homestead along with the husband who's on the deed,
She doesn't sign-
then
she
you're gonna have
doesn't
a
sign for the
problem with
homestead,
her
no.
She doesn't have
You
to.
guys have to
She
sign.
doesn't have to.
She doesn't have to.
She can't file for homestead, she's not an owner.
Okay.
This benefit to apply do you have to register as homestead or?
Mhm. Now, here's the deal.
How can you modify that after?
How can you what?
Modify it.
Quick
Modify
claim.
what?
That put my new spouse as a homestead in the house.
An attorney.
No, they have to
You
buy.
only one person has to file a homestead.
Right, they have to purchase the property with you, correct? No. So they should be homestead. No.
Only one
See, this is what I'm talking about.
No,
They would sit there and kept explaining it to each other until I jumped the case. Now, here's what we're gonna do. I'm gonna go back to the beginning, and I'm gonna come forward. The first person that talks, I'm skipping what we're doing. And then you can do it. The homestead is a person or person's primary residence. In the state of Florida, it has many benefits. One being the tax deduction, which to me is the minor one. You also have protection from outside debts created by one or both spouses. When you have sole ownership by one of the spouses, there is a protection within there that the spouse that is on the deed and owns the property cannot basically leave the spouse and kids out in the cold. But remember that when it comes time to sell or the person dies, if it comes the time to sell, the spouse that's not on the deed has to sign to eliminate his or her homestead rights. That's the only property that you have to do that. Any other property, if you're on the deed, you're on the sales contract, and you're on the deed, giving it to the next person. That's simple. Yes.
quick question. So what if they have like a prenuptial agreement or?
Call your attorney.
Okay.
Next.
Let's say in my case, I'm buying a house right now. And what happens if I marry again in 2 years?
Uh-huh.
That person is gonna have the right on the house. If
What do
something
you,
happens to
you
me.
mean, are they gonna be an owner?
No,
Is that what you're asking
he's
me?
not gonna be an owner. He's just gonna live there with me.
Okay.
So if something happens to me, is he gonna have the homestead right?
Yeah.
Eventually?
Yeah.
How can I omit that?
Call your attorney.
Okay, because he's not the dad of my kids,
Now,
so.
you understand what I'm doing, people? The questions they're asking are questions you could be asked by a buyer or seller. And you see how I answered them. If it ain't that damn book, I know the answer to the questions. I can tell them a whole bunch of stuff. But unfortunately, I left my little badge behind this morning that said attorney. Because you're gonna be asked questions like that. You're gonna deal with subjects like this. Because you know what? People are gonna ask questions like you are about homestead, because it's very different here than it is in other places. And I wanna make sure that my buyer takes benefit of that.
My next question, I will call my lawyer.
Question. If it gets to the children, and they're going to inherit this property and it's homestead, but they're not Florida residents, then it's not going to be their primary, what happens to homestead?
They don't get homestead, they still own it.
They still own it, but they don't get the homestead value.
Tax
Okay.
advantage, yeah. See, the only thing that's lost is the tax advantage.
Well, do they have the protection under the homestead umbrella of
No.
outside forces?
No, you're right, they would not.
Okay.
If a family lives in a primary home, but they do not register as homestead, so they have
No,
no
have
problem to sell it.
Well, you have to register one time.
No, but if you do not do it,
Right.
because of lack of knowledge or whatever, you didn't do it, but you have to live there for 3 years. So you can sell it without any problem, right?
Of course.
You will not have that problem.
You just don't get, you don't have, see, what you really don't have is the tax benefit.
Yeah, but,
That's what you don't have.
and the other benefits of that, I mean, outside that.
That's why you encourage them to speak to their attorney to determine, given their estate, what makes the most sense. Because yes, we have a lot of people coming from a lot of different places, and which way to go with ownership depends. I've seen a lot more LLCs floated out there in the condo, single-family world. There for a lot of reasons. Of course, when you get into your condos and stuff, and you get into your 55 plus, you get into all kinds of different things. That's where the trusts are starting to go. But even with single families, I've seen a lot more trusts as a part of the LLC. Yes.
Now, my husband and I, we have a home, but we're planning on purchasing another one. So now, does the homestead?
It's your choice as to which one you make as your homestead. But you have to be able to document that it's your primary residency. If you don't file your taxes there, you don't get your mail there, it's not a homestead. There has to be something to say that this is your primary residence.
What happens?
You can't just tell them that.
What happens
You
if
have
live in
3
another
years
state
to
as well?
transfer
Right.
to save your home homestead.
Probably you have that property and you can lease it, you don't rent it.
No, the second you rent it, it's not a
Yeah,
homestead.
but if you empty for, I don't know how many months you have to, but you still can apply as a homestead.
As long as you're declaring it as your primary residency, yes. Which means you're gonna have to file your taxes there and do, you know, your driver's license needs to be here. So everything that would say you're a Floridian.
I don't know if my question is similar to you, but I have an investment property and I bought another property. Can I transfer my homestead rights to the new resident, to the new?
Are you living there?
Absolutely.
But you have to.
Yeah.
I have to?
Yeah, because if you're not living in the one that you had the homestead benefit, you're not entitled to keep them. You're supposed to turn yourself in. Seriously. If you move from, you buy another house and move to this house, and this is no longer your primary residency, whether you're renting or not is irrelevant. This is where you get your mail, this is where you're filing your taxes, and you don't tell the county, you're gonna get hit with back taxes, interest, and penalties.
Okay, but can I wait for the beginning of next year? Or this year?
Yeah.
That's what I need.
What about snowbirds?
What about
What if they have two homes?
which one's their homestead?
One's homestead,
Which is
one's
primary.
secondary
Okay.
residence.
You have to declare.
But you're allowed to have a second home.
Yeah.
The second home,
I'm
as long as they
interested
stay
in
there
her
2
question,
weeks
though.
out of every year. they're
Like she
allowed to
mentioned,
live
if you have a home,
Second
if she
home.
purchased a
A
home,
condo, really, a town.
somebody moves in,
Yeah.
does common law marriage affect? I don't know if this law has that, but.
No.
does that affect it?
No.
Residence in a window.
So as long as they're not married, he doesn't have a say in the home, in terms of,
Oh, even if they are married. If she bought a home tomorrow,
and she died,
and let's not do too many things at once here. She bought a home today, she gets married tomorrow, she dies the next day. Primary residence.
We're waiting for you.
so he gets a life,
Most of it gives life.
So we allow you.
and the children get the home.
Right.
He can't sell it, right? And the life estate?
Yeah, as long as he can get the kids to sign.
And if they're minors, then they
Oops.
can't.
The court will appoint a representative
Those
for
things you
them.
have to wait until
Court
the.
appoints
No.
a representative.
You petition the courts to be able to sell the property.
So you have this property and, the husband dies and the wife is the homesteader. And when she dies, if she has a life estate, it goes to,
Wait a minute, you said she was the homesteader, that means she was no.
she was the ugly stepmother's second wife.
But she wasn't a homesteader.
Well, she was getting homesteading benefits
Why?
because that was her primary residence.
And she was an owner?
I don't know.
If she wasn't an owner, even if it is her primary residency, she doesn't get homestead benefits.
So her
Then
name
we
had
get
to
it
be
through
on-
the other spouse.
Her name had to legally be on the deed some point.
Yep.
Okay,
So
so,
that if the other spouse died,
yes,
she'd be able to carry on.
okay, so that happened, so her name must be under deed. But then she died, so the home reverts to the children. But the children are remainder now, not the other reverts. I'm very confused by those two terms.
If both spouses are dead, the house belongs to the kids.
Yes, but what are they called? Are they remainder?
Remainderment.
But even though the house reverts to them, they're not the other reverting?
Doesn't revert to them.
Just when you.
Revert means it comes back. It's
Comes back.
not coming back to them,
It's
it's going to them.
It's going to them, it's going back to the trust, and they are the beneficiary.
So to take your trust interest, yeah, it comes back to the trust, and then whoever, at that point, is appointed the trustee, which may not be either one of the original owners, because their mom and dad are both dead.
Correct.
So that's why it gets complicated when you have these type of ownerships. And the homestead just throws more mud into the situation. Yes?
I have a question. I have a house, and it's a homestead. No husband, no partner. I have a daughter. What happens if I die? And she is minor.
Number one, it'll probably go into probate.
Okay.
Or
What
if
is
you have
probate?
an appointment.
Probate means that the courts have to decide who owns this property. And if they're not of age, who's gonna take care of it for them?
A court-appointed advocate, which I've done.
What if she left?
Oh, so it'd be like, they would offer like the uncle or the godfather.
No, not necessarily, they don't necessarily do family.
Use the will as a guidance
For obvious
as to
reasons.
how the parents would have wanted it.
Now, listen to me. This is fun,
Attorney.
and I enjoy doing this. But let's translate this into being an agent, which you're not doing. You're not thinking like an agent right now. And it's gonna pose a major problem for you, even if you get back past the test. When you get out there in real life, you know more than your mouth should be talking about. I mean, I go in more depth with a lot of this stuff because I want you to understand the, the backside of it. But it creates what we just saw tonight. You see all the type of questions you were asking me. Stay in this room.
We could never.
Stay in this room. Any questions you have about your estate or about your homestead or any of that other shit, go see your attorney. I am not responsible for it. Because I've had people wanting to kill a spouse when they got home by the time.
Well,
Especially when they found out they weren't on the deed. So, needless to say, that could be negative. One more thing here, and we'll move on. On page 173, line 17. Personal property. You have a safety deposit box with stocks and bonds worth $500,000 in bank. And a safety deposit box. You are the only one that's allowed to open that box. You are now laying on your deathbed. You grab your 23-year-old grandson and tell him to go down to the bank and there's a person that Sally that he's worked with forever, and they're able to authorize the 22-year-old to get in a safety deposit box and take all that stuff out. You can, but the point is, if the state gets there before you do, the state's gonna put a seal on it, and nobody in that bank is gonna let you in there. And guess how much of that 500,000 you're now entitled to? 1,000.
No.
That's what it says right there.
And the rest?
So the best thing to do.
The rest of it goes to the state of Florida.
What?
Wow.
That's why you don't leave your estate hanging out in the wind so Florida can take it away from you.
That caused a civil war.
Florida's not the only place that has those kind of laws.
Yeah,
You
that's why
can look at the
Confederate
unclaimed
was-
properties on the state website, there's a lot of money.
Right.
Exactly
From
why.
people that die in banks have no beneficiary, that after 5 years the state listed and you can see if you have money left for your stuff.
Because I'm sending my grandson to the bank to get all that out of there before the state, stocks, bonds, cash, whatever it is I have in the safety deposit box that has value.
And it's
So,
illegal.
if you and your son, like you have a safe deposit box, so let's say $1 million.
That's why it's important to have someone else who's authorized to be able to go into that safety deposit box. Or the bank's not gonna let you in,
Exactly.
So,
because if they could be in violation of the law if they let you in when you don't have the right to be there.
this is under homestead protection. But if.
No, well,
That's what I'm confused about, because it's named, the stocks and bonds are in a trust name.
mhm,
So doesn't the trust have protection?
depends on how the trust is written.
Or a shyster lawyer?
Not necessarily.
It's there, but because, what about the house that's full of antique furniture that's worth 200, 300,000? We had, I remember a situation with one of the companies I worked with. This agent takes a listing on a home, and 3 weeks later, the husband dies. Intestate.
Oh, brother.
Now, they called, the wife said, please call my attorney. So the agent called the attorney, explained what happened. The attorney says, I'll take care of it. In less than a half an hour, there was a U-Haul truck in front of that house. They took all of that furniture, all the personal property stuff, and put it in a warehouse in her name. Because if they left it in the house, and the state got there,
They would claim it. Wow.
Why is the
Can
state
you-
so crooked like that?
it's not crooked.
Can you remind me, I remember Dade County was any assets over 3,000 or more have to go to probate. What was Palm Beach limit, do you remember? But generally speaking, folks, if you have 2,000 above, you should make a will and put the right beneficiary designation, or else it becomes a nightmare. You don't have to be millionaires, you just need to put the right for everything you have. Even bank accounts with $500 end up without a pay on death or a joint person, and it goes into limbo for years and years and years.
Wow.
Does it have to be specific, or can it just be like, give the kid everything? Like, do they really need to go into depth? Like,
Well, it depends on the bank. Depends on what their requirements are. And I don't know the details of what the law requires of those things. If I did, it'd cost you a hell of a lot more money to get in this room. If I knew as much as you think I know, it would cost you $4,000 or $5,000 just to show up each time.
She works at a bank, she does.
But the point being is, I get involved in situations like that. It's not gonna be unusual. So I need to make sure we have it, our corporate attorney cannot help your clients, customers. It would be a conflict of interest. But we have 2 attorneys at the title company, we have 2 or 3 other attorneys that we work with. So we have plenty of legal advice.
They can represent us though, as agents, or we have to have our own?
No, the corporate attorney can represent the sales associate.
Okay, because our E&O is covered by the
Mhm.
firm, okay.
Yep. Okay, let's continue. Middle of page 173. Bracket from 19 to 45. Nope. 45, and then to line 6 on the next page. Actually, to 13.
I'm sorry, say that again.
On 174, 1 through 13. We've already talked about these. One thing we talked about is that the intensity at will doesn't have an expiration date and can be terminated at the will of either party by giving proper notice. What we didn't say is, well, how much is proper notice? That's the top of page 74, right. Now, 174. If you pay week to week, it's a 7-day notice. More likely month to month of 15 days, which means that if you're a tenant and you're staying in there under a tenancy at will, and you don't want to be liable for next month, you're too late. Because it's less than 15 days until the end of the month. Which means you'd have to give the notice next month. Because it has to be 15 days before the next payment. So that means you'd have to be able to do the math on. All right, next couple of pages, we get into our joint tenancy, our tenancy common, and tenancy by the entirety. Let's take a look at this chart, if you will.
Which one?
The one on 174 that says concurrent ownership. Means there's more than one owner. More than one owner owning it at the same time.
So let's say if my dad hits the bucket, covers it, and he has a house but he's not finished paying off the mortgage, would I have the option to take over the payment?
That depends on the bank.
Oh, okay, so they would have to like check my credit and revert it to money and all that.
Yeah. Well, they just tell you you have 60 days to get out.
I might not want to pay for it anyway.
Especially if you owe 150,000 on it, it's only worth 150.
Nah, he
Isn't
wouldn't
there
do it to me. He would
umbrella
make sure that-
insurance in that scenario?
What?
Isn't there like an umbrella insurance that?
There's insurance to cover, yeah, and also in how you set up the estate.
Oh, my dad has life insurance, so I'm sure it'd be like,
But it's not just that, it's also using these different estates to protect your assets. That's why you sit down with a financial planner who helps you figure out how your estate should be set up. Because everybody is different. Who you want to leave it to may be totally different people. We've had several situations here where they were looking to left to the dogs.
the dog,
Dogs. I'll tell you that.
somebody who's.
All right, looking at our chart. There's one thing right off the bat that they have in common, is there has to be 2 or more people. Right?
Yeah.
No. Can't have 3 people in a marriage in Florida.
Why not? 2, just.
You said it's possible, you can,
3 people is the minimum.
or you cannot.
What do you think?
I prefer to say you can, I don't want to bring another wife into the house. I mean, you said you can, you cannot.
None.
Any mistake in you, you want to say something, excuse me. Is she the boss of the tree?
No.
Yeah,
Okay. In a tenancy in common, do they all have to become owners at the same time?
No. No.
No.
It says under tenancy in common down, there's one that says same or different time. So that means that as in a tenancy in common, owners can come and go. Let's assume that we had a tenancy in common composed of 3 people. Could each one of them, and let's assume that they own 3 properties, could each one of them have a separate deed?
Have a separate one?
A separate deed,
Oh, separate.
with just their name on it.
Oh, really?
No.
My question is, can you do that?
No.
Yes, because it says it right in the book.
Oh, yeah?
What's it say?
Same or different title?
Oh, yeah.
Same or different title?
Yeah, I didn't read that.
I know. Now, I did this little routine in one of my 1-week courses years ago. I had a gentleman in the room, who was a pain in the ass when we get to him, lit into me like unbelievable, telling me that what am I doing telling these people information that's totally incorrect? I've never seen anything like that, and I've been in this business for 30 years. I finally got him calmed down. And I had one of the other students came in a little early the next morning, and he handed me a piece of paper. What he handed me was a deed, and showed him as a 1/3 fee simple owner of X property, which means there was at least one other deed, and probably 2. Each one of them had a deed that said they were 1/3 owners. I did everything but make that a guy who had his big mouth. He didn't say shit for the rest of the time. See, I learned a long time in this business, don't ever say something doesn't exist. Because the minute you do, somebody's gonna ram it down your throat. And in today's world, we've got technology to help us find answers that in the past, you might spend a year trying to find something that you can do in 15 seconds with Google. It's amazing. I mean, I think about that in some of the questions that we've asked. And it's the type of stuff that we've had to done all kinds of research to get an answer to it, and it pops up on the screen. It's great.
So no right of survivorship means what?
Means, well, let's talk about what right of survivorship means. Right of survivorship means that if one of the owners dies, their rights automatically go to the other owners. The joint tenancy has right of survivorship. The tenancy in common does not. Which means in a tenancy in common, when one of the owners dies, their rights go to their estate. So survivorship doesn't mean it's going to their estate or to their heirs. It means it's going to go to the other owners.
Oh, okay. Like a husband.
I said the other night, that was the one thing that threw me off. It took me the longest to get straight. Because I used to think of survivorship, well, kids would get it, family would get it, whatever. It means just the opposite. In this discussion, survivorship means that the other owners will survive. Not that person's estate.
So it doesn't go to the heir?
No. If there's survivorship, no, it doesn't go to the heirs. So in joint tenancy, you have survivorship, so it doesn't go to the heirs, it goes to the other owners. In tenancy in common, it goes to the heirs. or the estate.
So, but,
Which means the
Oh,
other,
no, yeah,
wait,
yeah,
it
it says title,
I
I said deed, it's the same thing?
Well, yeah, because how do you get a title?
How do you get a deed? How do you get a
Because
deed?
title is the bundle of rights.
Yeah, so that doesn't say deed.
It means that they're legally on the title, which would be evidenced by the deed.
So they're on the deed also.
No, they're on the deed.
On the deed. They're on the deed.
Hold on,
They have title rights and they're on the deed.
I just wanna be clear on this. So in the tenancy in common, is no right of survivorship for the other person, but if my kids,
It says
if I have kids, then they will go to the kids,
No,
No.
no? So just go back to the state, that's it?
no. Is it a homestead? You talking about a homestead or just any property?
just,
Well, if it's a
Okay.
homestead, then it will be to the kids, but if it's no homestead, it will go back to the state.
Well, probably what's gonna happen is if you have kids and you die without a will, it's gonna wind up in probate. Which means the court, translate to plain English, the court's gonna try and figure out who owns this property, who has rights in it, and how are we gonna distribute those. That's why you don't leave your estate sitting out like that.
so the common and tenant and joint tenancy, one goes to the rest of the owners, or rather the owners inherit, you know what I mean, the other
Mhm.
owners. Right of survivorship, that means the kids can.
No.
The other spouse.
The
No,
other-
Oh,
you
yeah.
gotta keep that right of survivorship straight, people, or it's gonna screw up half your questions.
This,
Because they know that that's a place that everybody gets a little squirrely with, and they're gonna jump on it. So you have to stop them and think before you answer, yes.
the term survivorship, does it show up some way where else in this where it doesn't mean this?
No,
Okay, so this is the only way we have to learn it.
yes.
Thank you.
Tenancy in common, if you can have people that have 10%, another one 25, etc., different percentages. But even though they have less or more, if one of them dies, then you have to include their heirs. or no?
No.
You know, you talking about tenancy in common?
Yeah.
No.
And in tenancy
I
in
mean,
common,
yeah.
their rights in the property go to their estate. If it's a joint tenancy with the right of survivorship, then that owner's rights goes to the joint tenancy.
You mean that the state, I don't get it, in the tenancy in common, what do you mean their state?
Government, you take it.
What's left of them after they're dead? Which includes property, which includes persons. That's their estate.
What would you do with that, like, if you go and buy something with somebody and you don't wanna, basically, it's like giving everything to the state. I mean,
What are we giving to the state?
well, because if somebody dies, the other one is not gonna have their survivorship.
Well, it depends on how the estate is set up. If it's set up as a joint tenancy with the right of survivorship, or if it's set up as a
Yeah, that's what I'm
tenancy
saying.
by the entireties,
That's what I'm saying, I wouldn't do that. I would do the joint tenancy, or I would do the tenancy by the but I wouldn't do that type of thing. I mean, it's not very practical at the end, because you don't know when you're gonna die.
Oh.
Okay.
a tenancy in common is typically how people who get together in a partnership to buy and sell real estate. It's where you'll find the.
Like, more like a business?
In a business, you're more likely to find the joint tenancy with the right of survivorship. So that the two owners of the restaurant don't have the families come rolling in if one of them dies.
Ah,
And a
okay.
tenancy in common, they come rolling in. Now, here's a question. Let's assume we have a joint tenancy. And I decide that I've had enough of you. And I want to sell out my interest in the joint tenancy. I have someone who is willing to pay me amount of money that is acceptable to me. Now, unless the joint tenancy is set up to prevent you from selling without everybody's permission, and let's assume they didn't do that, I sell it to another person. Can that person come in as a joint tenant?
Yes, joint common. If the others agree.
Yes or no?
Yes.
No.
No. Why?
They have to agree.
Those have to be the same.
Because it all has to be at the same time.
Okay, yeah.
Then what do they come in as?
Afterwards.
Yeah, so that would be tenancy in common.
A tenancy in common. That means that I have a tenancy in common. The two parts of the tenancy in common is that one person and everybody else. See, the joint tenancy is still there, but the overall is not a joint tenancy anymore. It's a tenancy in common. Because a owner can't come in at a later date in a joint tenancy. That's why they say same time, whereas the tenancy in common says same or different. I have a question for you regarding the tenancy by the entireties. It says interest equal, each 100%. That's 200%. If they each have 100, that's 200, isn't it?
Yeah, and that is,
It's an undivided.
but that means
Equal.
Can you tell me why it says 100%?
I don't know.
I'll give you a hint. You would find it in a book that's been published for a couple thousand years. That says when two people get married, they are
One.
one.
Also, if one dies, the other one gets.
So it's 100%.
Still one. I just have to prove one of our one is not here anymore. Religion people throughout, all kinds of religions throughout history have had an impact upon this type of stuff.
What will happen if you have a photo wife?
I tell you what, if I could have more than one wife, and I even thought about that idea, I would have somebody shoot me. And if you say anything to my wife about that, you'll never pass this test.
Or being a Muslim.
Yes.
Yeah, well then.
All right, moving on 175. We need to put a bracket from the beginning of the page to the end of the page.
Oh, gross.
There's no start so far.
Now, all of what's on this page, we already talked about for 14,000 hours. So there's nothing new on the page. What I do want you to highlight and star is on line 14, actually, I'm sorry, 13, where it talks about right of survivorship. Wherever it says right of survivorship, I like the sentence.
Star?
And it is a star. On page 176, you've got 3 paragraphs to put a bracket around where it talks about tenancy by the entirety.
What is that?
Yes. And take a look at the last paragraph, it starts on 15. Yes.
If, I come across a scenario where I'm the representative of the buyer, so it means that I'm waiting for them to secure mortgage or financing, and as part of their process, they wanna use one of these trust or, legal entity. At what point are we required, or if not, to kind of know what their status is with the mortgage, because there may be delays in order to,
Well, I think what you'd find in most cases, or something like that, if they were buying it together, but then they wanted to put it in a trust, I think more often than not, they would recommend that you go through and buy it. Once the deed has been recorded, then you can go in and set up your trust.
because I know it from the bank side, but that's why I
Because
want
if
to
you wanna put
clarify
it-
from
if
the
you wanna
real
put a
estate
trust
side.
On that property, and you don't even own it yet, it's kind of hard to put anything on it.
Okay. So we.
It's like the illustration I did the other night with the life estate. Where the husband and wife and her father, and he was the one that wound up buying it. And then they switched it to a life estate for him, and named them as remain with joint tenancy with the rights to
So after the closing, they can handle that with their attorneys. Okay.
That's exactly what happened. She said, I knew that it could be done, I wasn't exactly sure, so I wasn't gonna tell the buyers. And I called up one of the processors, and I did a lot of work with, and she says, yeah, here's what we do it all the time. And, but we won't do it until the deed is recorded from the sale. Purchase.
The title company that we work with, would they also be privy to setting up, after it's recorded, they can have the documents already prepared, and then once it's recorded, they refile? Okay, I just wanted to be sure that, so that there isn't a long lapse in time to get it done. Okay.
Because you realize the people signing are the people that were on the previous deed. But that's why you've got to wait until the deed is recorded. If you do it before the deed is recorded and anything goes wrong, you've got a nightmare. Okay, last part of the chapter talks about co-ops, condos, and timeshare. Before we turn the page, I have a couple questions. In a co-op, do you own Unit 203?
No.
What do you own?
A share.
A share of what?
Of the building.
Of the corporation that owns the cooperative. Now, how are you able to occupy Unit 203?
Whenever they allow you to.
But there has to be a document, people. They just don't allow you to do something. There
Yeah,
has to be a
exactly, it
document.
has to be specified.
It's called a proprietary lease, which to me is the weirdest thing in the world. Proprietor is what? The owner. So it's an owner's lease. So I'm leasing it from myself. Because I own part of the corporation, therefore I'm leasing. Yes. Yeah. Fort Lauderdale, Hollywood, there's a few. But Florida was the first place where the condos really took off. First place where the timesharing actually kicked off too. In a condominium, what do you own? We know in a condominium we get a deed. What do we own?
Inside the wall.
Inside the unit, yeah.
Basically, we own space. We do not own the building. That's why we don't need homeowners insurance. But the condominium has insurance. which we pay for as part of the monthly maintenance. So one thing makes them different. Physically, you can't tell the difference because of the same type of structures for the most part. But when you take a look at the ownership, that's where you see the difference. And they still pay property taxes. What happens if the corporation goes under?
Bankruptcy.
You're right.
So then you're screwed.
You're screwed. Because that corporation just went down, you have stock in, and your stock is now worth nothing. Definitely need to call your attorney quick. If you'll notice at the bottom of page 177, where it talks about cooperatives, it mentions that proprietary lease.
Right to occupy the.
Do we need to bracket or like?
Yeah. Starting with line 18. Keep going to the next page to line 21. No stop. No, all the way through. One, no, not that. Just the last paragraph. If you're gonna buy it into a cooperative, and it's a new one, how long do you have to review and change your mind?
15 calendar days.
15 calendar days. How long do you have if it's a resale?
3 business days.
3 business days. That's in the second paragraph on the
Is
page.
that important to know those dates?
Yes.
When is the 3 business days at?
Figure 8.5.
Yeah, if you look at that little figure in the middle of 178.
That's fine.
No. Now, in the condominium, you always hear about the condo docs. In a new condominium, it's 15 days. In a resale, it's 3 business days.
That is after you sign?
Yeah. No, it's
After
it's
the-
after you receive the condo docs. If they give you the condo docs for at least 3 business days before you sign the contract, then you can't use that as an excuse to get out. But in most cases, they don't turn over the condo docs until we have a contract.
Okay. And you just have 3 days after.
3 business days.
Need the attorney to request a copy before.
And if you go into the property management office to pick up the condo docs, because you need to send them to your buyer, they're gonna make you sign for those condo docs. And the second you sign, tick, tock, 3 days starts right there. And you've got to Fed Express it to Canada. That's gonna take 3 business days, which means they'll have 0 days to review those forms.
Wow.
Now, I know that all of you in here who bought a property here, a condominium, or any type of property, you know because on the contract, it specifically states what I just said. If something is given to you as the agent of a buyer or seller, it's as if they gave it to you. But I'm sure your agent was well aware of that.
And then
There
it
was
sits
no
on the
airport.
back seat of the agent's car there.
To the land. So you can take,
Well, I guess I'm jumping to 30,000.
Yeah. no, what you do is you put on the contract under additional terms that the 3 business day review that the buyer has the right to does not start until the buyer receives the condo docs. And then you cover yourself. I would like to be able to have to tell a potential buyer who's decided they don't want to buy it and going to use this to get out, that they can't. Because you forgot what it said. That should go real well. Now, on page 178, at the very bottom of the page, last paragraph, it talks about the condo docs. Let's put a bracket around 35 through 42. Continuing on the next page down to line 21. Because this section here has 5 bullets. Those 5 bullets are the 5 condo docs.
Are those important?
Yes.
Extremely.
Do me a favor. No, actually yourself a favor. Don't ask me that question yet. Because it's so far, how many times have I said no? None. I told you a long time ago, if you ask me, is it important? I'm always going to say yes. Because I'm not going to get nailed to the wall by saying no, and then it's your first question on test. I had that happen once. That was enough. Well, fortunately, she passed. That'd have been deep doo-doo if she hadn't.
Nah, you would've just, you know, give her that 22.
I couldn't, it was a state exam, not the last time. So the declaration of condominium is the document that actually creates a condominium association. The articles of incorporation, probably sounds like the Secretary of State. Bylaws of the association, this is where they have the authority to tell you what you can and can't do. Frequently asked questions, and estimated operating budget. That's the hardest thing to get your hands on, because they don't like turning that loose. I want to start on the first bullet on 178.
Condominium?
Yeah, the declaration of condominium.
In the first one.
38.
The declaration of condominium. And then on the next page, the last one of the 4, the estimated operating budget. Start. Yes.
Is there a rule in Florida regarding the reserve or escrow account for the association regarding, repairs?
Yeah, there is.
There's a ratio or percentage that we need to keep?
I don't know that it's a set number. I think because that may vary depending on the association, what they need to have reserves for. On the last 2 paragraphs on 179, it talks about disclosure and cancellation period. Those 2 paragraphs have a start.
22 to 37.
Yeah. And notice the time frames is the same. 15 calendar days if it's new, and 3 business days if it's a resale. And then the last thing, and take a couple minutes to talk about, is time sharing, which starts from the bottom of 180. Not a bracket.
Yeah, don't you need to get like a lawyer to get out of the timeshare? They have services though that get you out of them. Why would you need to get out of a timeshare? Well, no,
Because you're not using it,
Oh, okay.
and the taxes and the maintenance have gone out of sight.
So in 180, what happens?
Nothing?
Let's start calling you sorry.
Why would I buy a time sharing? Because I love vacationing. That's the only reason to buy one. They are not a good investment.
Why is that?
Because they don't go up in value.
Because of
The
the,
key to buying time sharing is to make sure that you buy a place where everybody would want to come to.
No.
So something tells me that Weston would be a great place for a time share.
no, it has to be on the beach.
No, I don't. No, I
Get a place in
don't. From Weston, you jump onto 595, and you can be anywhere in Broward, Dade, Palm Beach County within an hour.
But the traffic is terrible.
It really is.
Well, they came from New York, so the traffic won't bother them.
Oh, yeah.
They'll think it's, there's no traffic.
Well, yeah, that's.
The vacation village.
Yeah, Vacation Village, yes, that's the one I'm thinking of. The reason for my statement is this. If you buy in a place that nobody wants to come, if they can't get people to come in to take your week, they're not gonna let you exchange it. To show you what you can do with this, I worked for Vacation Village for about 6 months. In the early 2000s when real estate was doing real well and nobody needed training. They probably needed it more than any time, but they weren't willing to pay for it. And besides the fact, I always wanted to learn more about timesharing. Simply because of being able to come in and I'd have to read off the page because I'd never experienced it. One of the vice presidents, she had 12 weeks. And all of them were bought in Vacation Village because it's such a popular place. It's very easy. I know that because when I was in there doing sales, we would take them around to the different buildings and stuff, kill time, take them out in the Everglades, on airboats, talk to them for 2 or 3 hours, and then try to convince them to spend 10, 15, 20,000. It was an interesting experience.
So you learn how to sell.
Now I learned that I didn't want to time trade. Now, if I was still vacationing like I did when I was younger and my daughter was around, definitely would be using it. We got a lot of benefit out of it. But here's what happened. She had 5 friends who had significant others. And they decided they wanted to go to Hawaii for 2 weeks. So using her weeks, because of the quality of them, that she was able to exchange to a place like that. They decided the first week it was going to be girls and guys. And then the second week, everybody come together. So That means she had to be able to book 2 weeks. Now, the exchange fee at that point, I think, was $89. But remember, she's also paying maintenance and taxes on those 12 weeks. But in a stroke, she's gonna get it all back. They need a place big enough for the 5 of them.
10?
And they wanted to be, well, that first week. They were 7. And, well, and you're right, they had the guys. They got 2 units, big suites. Those were either 3,000 or 4,000 a night. So let's say it's 4,000 a night. Times 7 is $21,000.
28.
Versus 28 versus $89.
I would just want a yacht.
Yeah, so it's good.
And then the second week was $8,000 a night for 89. So, how many of you think if you were a fivesome and your significant others, that you could afford that to spend the kind of money they technically would have spent? Not a whole lot. But that's the whole point. It gives you the possibility of going to places on vacation that normally you would not be able to afford. This is not something they sell to people that have a lot of money. This is sold to people who scrape money together every year to be able to go on vacation. That's the people that buy it. And I know people that swear by it. I had one couple in class, every Super Bowl, as soon as they know what the city is, they book and use their days. And they stayed in places near all the action for the exchange fee. They said the last one they were in was like $6,000 a day. Because you know, a lot of people make a lot of money in a week's period of time to rent out their places. I know people that had friends that every year they would book the place and go stay someplace else. They weren't into football, they didn't like football, but every time, so they made money all the time.
Plus, we have to travel to different places.
Mm-hmm.
I mean, we swapped out an international one and go to Europe.
Yeah. Yep.
Right?
So it's a matter of understanding how to use it.
But now they have Airbnb. Like I stayed in a penthouse condo, $50 a night
Yeah,
in
that's
Miami,
true.
on like the 50th floor. And it was only $50 a night.
That is true.
You'd be surprised, like you can get really good deals on
Yeah,
Airbnb.
that application is really good.
Los Angeles.
I almost wanted to move in, I was working
Correct.
on it. Sure they would.
Okay, next chapter. Page 188. 188. What is title? It is a legal bundle of rights.
Yeah.
What's the difference between a marketable title and an equitable title?
Equitable, they get the title at a future date, that's what it says here.
Give me an example of an equitable title.
A life estate with a
It's a
renovation.
document, I'll give you a hint.
It's the interest in
Nope. Deed gives you marketable title.
What do you, a life
Contract of
estate?
purchase.
What'd you say?
Contract of purchase.
Contract of purchase, yeah. Because is the seller not promising to deliver title at a future point in time? It's called closing.
That is where contract of purchase.
That's equitable title. It becomes marketable or merchantable title once they put that deed in your hand. And that there aren't encumbrances on the deed, or on the title actually, that would prevent the property from being, from the title from being transferred. Remember, a deed is simply a piece of paper that allows you to convey your bundle of rights, whatever that may be.
Dale, would you clarify something for me? When the title company the attorney does the title search, and they verify that it's a clean title, legal title, and they issue a title insurance policy, does that mean that they're certifying that it's good and clear and can be negotiated, right? Well, what if down the road there's a problem with the title? Because I experienced that in a situation before.
I'm gonna hold off on answering
Okay.
that question, because it's coming a little later.
Okay.
All right, tell you what, why don't we take a break here? And we'll crack that.
She grew up 16 and 13, and he was riding his bike in West Coast Park, and the driver hit him.
Did the person hit and run, or did they police?
Yes, yeah.
Thursday?
If that is plans that you made, lost to potential.
So he died on Sunday, their 18th wedding anniversary was Monday. He had a helmet on and everything, but
Yeah, but it depends because November I'm tight. I'm starting a complete remodel in November. I'm probably gonna work all the way through November, so just give me. Yeah, no, of course. Okay, let me know. I'll help you.
Yeah, but I would take it.
I'll give you some of my guys.
Yeah,
I'll tell my crew tomorrow.
yeah. So I need somebody, if he's not from the papa.
you ride a bike and oh my God, well, and there's people that come to I know. Thank you. I have a card too, if you want to sign it, thank you. Driving. Nellie, so.
The girl that was sitting next to you?
Her husband was killed on Sunday. He was riding a bike and
If you don't mind at some point, ask her if I can have her number.
yeah, absolutely.
That's a good one.
That happened a year ago, right by Jog in Linton. A co-worker from Manicure, husband living in Kings Point, was crossing the street. A 75-year-old in a sports car run the thing 7-car pile-up and held them right, walking right over to their. It was a nightmare for her and her family. Still, she hasn't recovered because financially he was the main breadwinner, so it became, you know.
Yeah.
Let me give it to her real quick.
I'm just gonna give her a check because I don't have any.
So out there. Yeah, I'm gonna hear
So that is how you met her.
That's good.
Yeah.
Thanks.
That is, I mean, I think it's safe, but I would be afraid.
She's in her 40s, so she's been with her husband for so I you know. Right, right. Yeah. Yeah. And her husband. When she messaged me on Monday morning, I was driving and literally the wind was knocked out of me, like I couldn't even. What's his name? B. Bronn. I just want to make sure it's 2 N's. Sorry. Bronn. B-E-R-G. B-E-R-G. Bronberg. R-O-N-B-E-R-G.
I don't have a check. This $20.
Yeah, I know. Absolutely. Thank you. I have a card and,
So how many of those do you have in your house?
honestly, I think that she's just gonna be, so touched that. Thank you. Thanks so much. You need a will. So, but it's really easy. So my husband and I,
Thinking about that.
because you have a daughter.
Yeah.
Oh my God. So, my husband and I have a lot of assets, and I wanted to make sure that my parents get them if we both die. It's just one of the sides. I'm fine with him getting it or me getting it all, right? My concern was that my parents held us a lot along the way. I want them to get everything. I don't want his parents getting half and my parents getting half. That's not my kids right now. So, my aunt is a trusted state attorney, but she couldn't write me really because she would be, if the question would be contested, because she's related to me, of course. So we just got like a simple will and used the forms and developed. I'm eventually going to get everything into a trust, but a will is the best place to see it. Really, honestly, if it costs $10 million, the trust is fine. Her daughter or her heir, whoever.
Computer and on the phone with the time. First round versus it's not like the same.
So they're worth finding maybe a lot more.
Right, but still, I always wanted to be, so probate isn't like the biggest deal in the company, but obviously it has to be if you don't trust. But like the probate taxes. So it's all obviously, we're going to figure out who does this go to and appoint somebody, then they can start deducting all these fees and, so if you have a will, it states who it takes your kids if something happens to you, or, you become incapacitated, it's just, it's so important, $40, it's so easy to fill it out, they just tell you how to fill it out, and then you go, like, a bank will not notarize a will, but like, you can go to the UPS store, exactly, you can go to the UPS store and make $10, they notarize it. Right. You don't know, you never know. She's still here. That same ring is for my mom. That's what I wanted. Okay. Yeah, that's what's gonna happen. Thank you.
I just throw it on me. No, I do, I just like, it was fun, I just. I probably work all day, so I'll freaking work all day. Oh, I should think it will come out? Watch it again this week. I just don't know what the hell this is. It has to be something hot. I think it was hot. If you have hot, something that's hot, you want that. So if we get the benefits of insurance. Yeah, especially at night. It's really terrifying because, you know, with the light and all the construction, it's not safe to ride your bike. No, it's not. I'm not away yet. I still can't see. But it's on the club. I'm sure.
We signed papers years ago, and he said to me, I never want you to have a little more table.
Is she has kids?
It really opens up a whole new world.
Yeah, we're currently here. All right.
My grandpa.
Oh, no. I have I'm okay like 100. Yeah, no, I just like this. No, that's just one of the little old school ones. It holds charge very well. Oh, that's not Oh, that's right. Yeah. I used to work at Hoover. I used to work on auto. I had transfer. No, I farm primarily. I Everything is kosher. Yes, it's getting expensive. They don't even ask me a week. No, because you gotta go to the from where you from. Yes, right. Apartment almost. Wow. Yeah, I gotta get here. Come close. I want to tell you what's happening. But if I have to come here, if I have to come on the weekday, that's hard. Thursday, I have to look at it. We don't have nonsense. We have both, I'm gonna die.
Okay, guys, let's get back to it.
1,200 units, but it's very I do. What I drive at night, it's very hard to drive. My son, my 20-year-old said, it's great to drive.
All right, let's continue with the chapter.
He's one of especially with construction.
The next part they talk about is acquiring legal title. And they talk about two ways of doing it. One's called transfer by voluntary alienation. The other one's at the top of the next page, which is called transfer by involuntary alienation. A deed would normally be voluntarily or involuntarily? Yeah, something you do freely.
Transfer by involuntary alienation could be a lien, in the case of a lien,
As far as what?
as far as the person put a lien on the property and then
We're not talking about liens. We're talking about transferring the rights to the property. We're not talking about putting liens on it.
not selling.
That's coming later. It's coming later in this chapter. This is not about liens. This is about transferring title. The two ways to voluntarily transfer title is by a deed or through a will. And you got all kinds of terms there in that paragraph under will. One of them should be highlighted and starred. It's on line 39. It starts about in the middle of the line. I'm at the bottom of 188.
Page 188.
A gift of real estate is a device, and the recipient of the gift is a devisee. And start. Bottom of page 188. The paragraph is talking about will. Like I said, there's a whole bunch of terms in there. So that whole paragraph needs to be studied together. Then we talk about involuntary alienation. The first one is dissent. Dissent means that you got what?
It goes down to the bloodline.
Without a will,
Without
intestate.
a will, yeah.
Now it just starts down your tree. Eventually, if it goes all the way to the roots, that would be the escheat to the state, which is at the bottom of the page.
Oh, that is what we were talking about. Kind of.
I take the, I take the E and the S off the front.
Yes.
Because ultimately, it winds up in the hands of the state of Florida, and there's no money there claiming it. And they may be claiming it, but if they can't verify something somewhere that they have the right to it. Now, obviously, in the state of Florida, given the average age on any given day, these kind of scenarios come up all the time. So that means, for example, obviously, you have a lot of situations where in these condominium communities, for people, the average age is 82, there's gonna be a lot of people passing on. And then the son or daughter or grandson or granddaughter show up with documentation to show that they are now the owners of the property. Maybe. Because you may have to go through what they call probate. That typically takes anywhere from a month to 4 months. So if I'm taking a listing on a situation where the person I'm talking to may or may not at that point actually be the owner, because they left a will, and the will said that it would go to my grandson Sammy. But there may be people in the family or in the tree that don't agree with that. And the title company, or the attorney that's doing title, is gonna look at that, and there may be a concern over who might actually have rights to this property. And you know that they're not gonna certify title, and neither is the title insurer. The insurance company's gonna insure the title. So it's gonna have to go through a process of cleaning itself out. And there's several things they talk about in this chapter that would relate to that. The third item under this involuntary alienation is called adverse possession. In a few minutes, we'll talk about adverse possession. But let's go to the next page for a second.
Hot can.
And under the hot can is eminent domain. The government's right to take property for public use.
Oh, so that's.
And how do they enforce eminent domain? Yeah.
That's like up north, like they'll take.
No, I want to know how they enforce eminent domain.
They pay a fair price?
No. That's not how they enforce it.
Oh, enforce it?
It's state or city mandated. They vote.
How do they enforce it?
Condemnation,
Condemnation. How do you know that?
because I just read it.
Oh, because you just read it. And your statement is also correct. It is a government thing. Now, one thing they have to do is pay you fair market value. And I've had several people in class who had their property taken to eminent domain. And they were able to actually, one of them doubled what he wound up getting paid. Because like any other investor, the city, county, whatever it is that's coming in to do this for the state, they want to buy that land as cheap as possible. That's why you have the right to challenge what you're being paid.
Like, for example, if you own a property next to a train track and they wanna widen it. or
It has
even
more
a-
value than it may appear to. I had a guy in class, he had a nursery between two office buildings. Now, when they invoked the eminent domain, they wanted to buy it at agricultural value. But that really wasn't the fair market value of that land right now. That land obviously had a whole lot more value for some sort of commercial use than it does for growing plants.
In that case, you can hold your ground, yes?
Again, you're not gonna prevent them from taking the property, not necessarily, but you've got a pretty good odds of
The money you
getting
get.
more money. Yes, ma'am.
Do they have to declare what they want to use that land for?
Yeah, yes, because you will, have you noticed when you drive down some of these roads, especially out west where it's still farmland, you'll see these orangish colored signs? Stop and read one of them. It's a public hearing. Because the land use is gonna change. Where Thomas Produce is at 441 and I've heard, and I haven't been able to document it, if you're familiar with the Delray Marketplace, supposedly in that area there at 441 and Glades, they're gonna put another complex like that.
Oh, wow.
That would be cool, because I live about a mile away.
They need another marketplace.
Yeah. Yeah.
It's really convenient.
A really good example of eminent domain is what's going on with this wall that the president wants to build. So they've been interviewing some of the landowners, and they've owned that land for generation after generation. And some of it even goes through the Rio Grande. I mean, I don't even know how they could possibly do all of that. But they've had a lot of programs on it, so eminent domain is really something that's important.
Absolutely.
Is that chart that says remember conditions for alienation by adverse possession important? I know that I should be asking if it's important, but you just said skip it.
I asked you
Just skip
not to
it.
ask me that question.
I know, but you skip it, so.
There is no but.
But you didn't talk about it.
Because you don't give me time to do it.
Ah, okay.
That should be fine.
I'll run it, yeah, so you can get you before you get sleep. Sir, you got another wake up?
All right, let's look at adverse possession. And let's look at that chart at the top of the page. The characteristics, and you organize them the way they have them, spell out the word hot can. Now, let's take a look at what characteristics this thing has in order for it to. It is a method by which one person can take somebody else's property. It says that, the first thing is that it says hostile possession of the property to the exclusion of the true owner or anyone who may contest it. Well, that would make sense that if the seller gave me, the owner gave me permission to be on the land, it wouldn't be hostile. The second one says open possession with no attempt to conceal occupancy. So you have to be doing things on there that would indicate that you are possessing it. You couldn't put a tent in the back of the woods where nobody could see it and hang out there. Which means that you could be doing some sort of agricultural thing there.
If you have a piece of property, right, and you don't want to sell the land completely, can you like subdivide it? So if I'm on a piece of 2 acres,
Yeah.
can I just sell an acre with the house and then build another house and make them my neighbor?
Depends on what the zoning calls for in that area. But the answer to your question is yes, if zoning allows. The third one says taxes paid. The adverse possessor has to be paying the taxes, which means if the owner pays their taxes every year, adverse possession will never happen. Because to kill this, all you have to do is eliminate one of the characteristics.
What about eminent domain?
Well, this has nothing to do with eminent domain.
Oh.
This is a one owner taking it away from another owner. So I guess you could say it's more of a private thing. Then it says, and the C is claim of title. Eventually, you have to go down to the courthouse and declare that you are the owner of the property because you've done all these things. The next one says adverse possession for how long?
7
7 years is an incorrect answer.
20.
The key word there is not 7. The key word there is consecutive. So if I let you stay there for 6 years and 11 months and 30 days, and then kick you off one day, the 7 years starts all over again. Which is why they said on the previous page, the owner would probably have to have fallen asleep on their rights. And the last one is notorious and flagrant public possession of the property, which kind of fits into the first one. In 40 years, I've had one, maybe 2 examples of adverse possession. Sounds a lot like squatters' rights, doesn't it?
Yeah.
Well, it is, but it's a little more technical. Let me give you an example, which I think is the best example I can give you of how this works. I had a gal in class whose grandmother bought a 5-acre tract of land in the Tampa area in, I don't know, 50s, 60s, somewhere in there. And they still lived up north. And every year, she'd get tax bill, $5, $7, $6. I mean, taxes weren't very much. That was basically swampland at that point. And so this went on for quite a few years. And then she stopped getting the tax bill. And she just figured that maybe there wasn't any tax, so she didn't do anything about it. The reason she didn't get the tax bill is because a construction company picked up the fact that the property right beside of theirs in this industrial subdivision was owned by an absentee owner. So every year they went down, paid the taxes before the bills went out. And the county doesn't care who pays the taxes as long as the taxes are paid.
Wow.
So the idea was this was going to be something that she could leave behind when she died to her family. But she decided that she didn't want to wait that long. And that she would like to sell the piece of property and distribute the money to whoever it is she was going to give it to, because she wants to see them enjoy using it. So they lived over here, the family lived over here. She would move from wherever she was up north. She refused to move. And she comes down on vacation. And they decide to go over and check out the property. Maybe list it with a broker or something. So they went over, and they finally, with all the maps and the survey and stuff, they were able to find the property. It was now a developed industrial subdivision, which means the land value was a whole lot more than what she paid. There was a building on there that had the name of a construction company. In doing research, they found out that, number one, when they looked at the public records, her grandmother were not the owner anymore, a construction company.
Oh my
Oh my God, they sold.
Because they met all the requirements, and then they went down and claimed title.
Oh my God.
Because what they first did, when they checked into it, what they first did was, is when they realized it was an absentee owner, they started paying the taxes. And then they put an old trailer out there, they mowed the field down so that there was that open, obvious, they're in the property routine. After 7 consecutive years or more, they were, if they met all the other requirements, which they did, they were able to go down and claim the title.
Yeah, it
You
is.
snooze, you lose. You abandon your property, which she did. The law says, let's give it to somebody who can use it.
It's like if I left my Ferrari in Dubai and I'm paying for insurance on it, they can just take it and give it to any one of those guys they want.
I don't know what it is over there.
No, I'm just saying that that's.
I have no idea. I don't think that's a good idea.
Well, no, because in Dubai they have a lot of cars just left there. Yeah, you can bring them up. You can buy a Ferrari online for 21 grand. You just can't ship it into the U.S. You have to bring it to the Bahamas first, and then bring it to Canada and drive it in.
Oh.
But I'm just letting you guys know.
Wow.
You
keep us a new, that's why,
Insurance fee is $1,000.
that's why it's 21,000.
Yeah, 'cause you can't get it here.
Yeah.
It'll cost you $800,000 to get it.
That's exactly. Wow, but that is really sad. That you do.
So that's.
Actually, maybe 6 months, a year ago, or maybe even a few years, a lot of these big homes, people abandoned them. They couldn't afford to pay taxes, whatever it may be, and they were talking, and then they found these squatters that are on there. And one of them was talking about taking the property through adverse possession. Now, the person they were talking to, I don't think they had the $200,000 or $300,000 in property taxes that were probably due at that point. Because they weren't looking at a little $100,000 house, they were looking at houses that were, $2, $3, $4, $5, $6 million. Because they thought they could pick it up from the taxes.
In this day and age, is it easy to find property like that?
You're late,
In rural parts.
you're late. If you'd been here 4 or 5 years ago, you'd had a much better shot at it. We have an agent here. She was an expert with short sales and foreclosures. She has stopped doing that now. It's not, she says it's not lucrative. It's a whole lot more work. And it's just not as lucrative as it was in the past.
It's like, everything repeats itself, so another 5 years, that'll be lucrative.
That's all. That's all.
All right.
Okay. Questions on the adverse possession. The questions you're going to get asked are off of that little chart there with the hot can. They're not going to give you a scenario, and you have to figure out if that's an example of adverse possession. They would ask something like, adverse possession requires which of the following? And then I start looking for these answers. This is not a start. I'm a bracket, yes. But not a start. On page 191, it talks about notice the legal title. Lines 7 through 18. It says today there are two types of notice that have equal legal priority. Actual notice and constructive notice. When you buy a property, which one of those two happens?
Constructive notice, construction. No.
What's that actual notice?
Direct knowledge required, was a transaction when the townspeople witness.
Number one.
Okay, it's when the owner disclose a lien on the property.
If you would like an example of the first one today, it's called closing.
The closing?
Yeah.
Yeah, that's big.
Don't people actually see you getting your title?
Yeah.
Don't they actually see on behalf of the previous owner, the closing agent?
Why wouldn't they just put on the closing?
Why what?
Is that like a term that's gonna be in the test? With actual notice? Should I just say closing?
Wait a minute, you gotta do me a favor. Ask that question again.
I don't want to.
I didn't ask whether you wanted to, it's not a question.
Alright.
What did you say?
I said, why didn't it just say the closing? Why
No.
did it have to say actual
No,
notice?
that's not the part I'm talking
I don't
about.
remember what I had for lunch. So for
Well, you better remember quick.
I'm trying to
His,
think.
his question was, is this something we need to know? His answer is,
Oh, yeah,
Yes,
title.
yes.
I didn't hear you.
Yes.
Thank you.
No, I understand that. I'm just talking
Then
about.
don't ask me.
That's true. That's true. Some of your questions are rhetorical though, so it puts me in a pickle.
Answer the question. Don't give me a dissertation of the information. Constructive notice is when you place it on public record.
Okay, but you know.
Now, question. If I decided to give, no, I won't do that. I can't use that example.
What did you?
At closing, let's assume that a property was being given to me. So, all the documentation that had to be signed, including the previous owner signing it. We did it at the title company. When they handed me the deed, which notice did I have?
The actual notice.
Actual.
Actual.
I actually have it.
Yeah.
But before I could take it anywhere, they gave me a copy of it, and they took it, the original, to the courthouse in order to serve constructive notice, to tell the whole world. So actual notice is telling the people that are directly involved in it. And constructive or constructive or public notice is just what it sounds like, telling the whole world. Which one's better? Which one?
The second.
I think telling the whole world.
It says on line 7, the first line of this, it says, today there are two types of notice that have what?
Equal, legal.
Oh, damn, isn't it amazing what happens when you read and not talk about what you think the answer is?
Well, that was a
Now,
tricky question.
I do not have to record a deed in order to have title. The danger of not recording it is I could lose it. And then I could no longer prove
That I am the owner.
that I'm the owner of the property. But legally speaking, both of those are legal.
Yeah.
I don't have to record my deed to have a valid title. The reason the deed is recorded is because of the bank, number one. And the title insurer, number two.
Why do
Because
you?
even though legally, if I've got the deed in my hand, I'm the legal owner of the property, it says so on the piece of paper, I actually have proof. They don't trust me.
I'm kind of confused because why do they bring it up, the example of the seller giving the buyer actual notice that there is a lien on the property? Why are they bringing that up there as an example?
Because that would be something that could affect the title. And me telling you about it will be serving actual notice. If we did a search in public records for liens and we found liens there,
Okay.
then that means those liens are under constructive notice.
Okay.
But this is more, not from the standpoint so much of liens and stuff, but from the standpoint of being able to prove my ownership.
Okay.
See, this goes back in time when we didn't have all the fancy stuff we have today. And a buyer and a seller would meet at the property, and the current owner would pick up a stick and hand it to the other person, which symbolized a transfer of title with witnesses. And then they'd go down to the recording house or courthouse or whatever they called it at that point in time. And they would put on public record that they had obtained the property from Mr. X. We've gotten a lot more sophisticated today.
Can you give an example when you can lose the title when you do not register it?
My grandfather gave me a piece of property. He had a deed drawn up, he signed it, it was witnessed. I've got it in my hand. But it has a mortgage on it that's about to come to maturity in the next year. And I don't want to take a chance that they may call it all due if they find out that I'm now the owner and not my grandfather. So I want to wait until the mortgage is paid off to record the deed. But somehow, I lost it. I can't find it.
And, yeah,
And I didn't record it,
yeah, so
so I got a problem.
that's why you have to record.
Gotta call your lawyer.
Not even, because you don't have proof.
Oh, you might.
Yeah.
It's called the witnesses. It's called the witnesses that may be on the deed, so you may have something you can do with that. In order to record a document, there has to be an acknowledgement. By who?
The current owner.
But the seller?
By a notary,
Notary, okay.
authenticating
Mm-hmm.
the signature. What, my question is this, and they talk about this in the paragraph starting with 25 to 33. Because, again, in order to record a document, it has to be acknowledged or notarized. And the notary is acknowledging that the person in front of their face is that person. The notary does not authenticate the document or the contents thereof,
No, just the signature.
just the signature. And that the person making that signature that presented themselves in front of the notary is that person.
How do they deal with electronic signatures on everything these days? It's great. You still have to have some of it notarized.
So,
Yeah,
Some
I
documents
still-
have to be
Well,
notarized.
yeah, see, some things still have to be notarized. It may not be done in front of your face, like it used to be. It depends. The lender may be one. Well, speaking of that, just to make you aware of something, with how things have changed with financing. Under these new financing guidelines, you don't talk about, if the contract, sale contract doesn't talk about obtaining loan commitment. It's called loan approval now. My daughter sold her house and bought her house this year. At the closing on their new home, it was just me, my daughter, and her husband, and the processor, closing agent. And went through the documents and stuff. And then they said that we have to send back to the lender these 5 documents. I wish I had asked them to, I should have written them down. Those 5 documents have to be sent back to the underwriters. Because this new statute requires that these documents are proofed after they've been signed, to make sure there isn't something missing. Why? because of all the shenanigans that went on in the last 15 years, the financing and the forgery of documents and signatures and everything else. So we sat there for 45 minutes. Everything's been signed. One thing they hadn't gotten yet is a check, because they had a net check from between the sale. Because we had a sale that occurred, the closings occurred the same day in two different title companies. That was fun. Trying to coordinate two sales with two different title companies, two different already with me. At the bottom of the page, it talks about what it called protection.
Protection of title. Chain of
How do you
title.
protect the title? You insure it. First thing we do is a chain of title. Palm Beach County, you can't really do chains of title. Chains of title says that you have gone back this far in time, and here's what the title looks like. There is nothing currently showing whatever that point is in the past till now. I don't know if you've ever noticed it, but if you list it with an agent, one of the things they would ask you for is a copy of your current title policy. And let's assume you bought the home 10 years ago. If you can provide them a current up-to-date title policy, they only have to search back to the date that policy was issued. And if the title is clear in that time frame, then they can clear it, a clear title, and be able to continue the process of closing.
I have a kind of dumb question.
No such thing.
I don't know why, but if I own my house, or my customer owns their house, supposedly the title belongs to the bank, no?
No.
So the person is the one that is gonna hold the title,
Yeah, the bank doesn't hold the title here.
no matter if they own a lot of money?
Bank does not
Okay.
hold title here.
Okay.
The owner. Let me ask you a question. How many of you own property here? And you ask me that question? You've got to be kidding me.
No.
The questions that some of you are asking me now, you own property here, it should be shit that you know. That tells you what kind of agent you had. They didn't make sure that you understood what was going on. I think agents are afraid that if you get too smart, you won't need them. It's just the opposite. The more you understand about the business, the more valuable a good agent becomes to you. Yes, ma'am.
In our previous explanations about recording the deed and then going back and readjusting it for legacies or whatever purposes, does that invalidate the title insurance? Or do you have to go back, like you change it
No.
from a single fee simple to,
No.
like, it doesn't?
I think they were able to issue policy
Concurrently?
simultaneous.
Okay, okay.
I think you can do it within a certain time period. And obviously, they could do a quick search to make sure nothing would come up
Because.
from the original closing until then.
Say, well, I had a situation that I went back and did a quick claim, reverting back 5 years to what it originally was. I was going into surgery and I wanted to take my name off in case I died. My mom wouldn't have to deal with all the, so I updated with a quick claim. And then afterwards, I went back and put it back to the original, what it was. And I was wondering, in a situation like that, if it creates a title policy, probably.
I'm not sure. I'm not sure. But I can give an answer.
I would appreciate it, because I'm
Send
thinking
me
of
an
doing
email.
it again, and I don't wanna get in trouble.
All right, under what circumstance can we give an opinion to title? None, thank you. Question, if I obtain title insurance, is that a guarantee that I won't lose my title?
No.
No.
So if you lose it, what you gotta do?
I don't mean physically losing it. I mean somebody comes in and proves that they were a previous owner and somebody forged their name or something.
So, yes, yes, in that case, yes.
It doesn't guarantee it, but it protects you that the insurance can litigate.
I'll ask you a question.
You can get away with it.
I'm gonna ask you a question. You got homeowners insurance. Your house burns down, or does the homeowner insurance prevent your house from burning down?
No.
Well, then title insurance doesn't prevent you from losing title. It reimburses you for covered losses, which means virtually nothing.
Okay.
Like any, it's an insurance policy like any other insurance policy.
Is it required here?
No,
Should you have it?
if you're paying cash.
Oh, is that
You know darn well a lender
It's not required.
is gonna require title insurance.
You don't need title insurance if you're buying a house.
Oh, if you pay cash.
And you'd have to be on drugs.
Yeah, for you not to.
I
Not
get
to.
insured regardless, especially if it's cash.
Remember, it's a one-time
There's a lot of problems.
payment.
Yeah.
On page 192, bottom of the page, there are two types of title insurance. The owner's policy and the lender's policy. The owner's policy, depending on the price, could be thousands of dollars. The lender's policy is normally, probably, a lot of times, under $100. The reason for that is all the searches and everything that they have to do to be able to issue the owner's policy are the same research they'd have to do for the lender's policy. So in reality, what's happening is all you're really paying for is the documents. Because they don't need to redo the same search for liens and whatever it may be for the lender's policy. That's why when you look at the closing statement, you see maybe thousands of dollars for the owner's policy, but the lender's policy may be $100 or less. Because all they have to really do is fill out the paperwork and have you sign it.
So,
Lines 34 through 46, star. Yeah. Star. Lines 34 through 46, I don't care if you bracket it, highlight it, or scratch it, put a stop sign.
Is there a star?
Up to what percentage is covered in the insurance policy?
Whatever the policy says.
So if the house is 500,000, it's gonna be a 500,000.
Normally, yes.
So if something happens to my house, I'm gonna get the 500,000?
No, it's not about your house. It's about the title to the house.
And the title.
Title insurance, let me ask a question. What would title insurance cover?
Title.
The house or title?
The title.
Why?
Because it's
Title
title
Oh,
insurance.
because it says title insurance.
Not home
Okay,
insurance.
I'm just checking. On 193, the 1, 2, 3, fourth line down, it says that the owner's policy is not transferable, but the lender's policy is. That has a star. Looking at the chart at the top of the page, go down to the fifth one where it says not transferable transferable on the owner's policy, but it is transferable
I think you're on a different page.
No, in the chart.
in the chart.
In the chart.
On page 193, there's a chart at the top of the page. One side gives you the characteristics of owner's policy, the other side the characteristics of the lender's policy. The ones that talk about transferability. The fact that the owner's policy is not transferable. That means every time the title is transferred, the owner's policy has to be renewed.
Is that a star?
Yeah. For the 10th time. At the bottom of the page, it talks about deed. I'd like you to highlight the bottom of the page.
That's the deed.
The whole thing with this part is for the
Lines 15 through 19. If you picked up your deed right now, would you be shown as the grantor or the grantee?
Grantee.
Seems the title.
Unless you are selling and you are the one.
Unless you're.
Nothing to do with
one
selling.
grantee.
Okay, so the grantee.
How many of you say grantee?
What,
Is the current owner of the property?
oh, the current, that would be.
I don't
How many of you
know.
say the grantee is the current owner of the property?
No.
How many of you say the grantor is the current owner of the property?
Yeah.
You dumb.
It's the grantee.
Guarantee receipt.
You don't even know what your damn deed says. It's not, you know what? It's not really funny.
It's wrong?
Yeah, it's totally
It's
wrong.
grantee.
Grantor?
Is the person you got the deed from.
Yeah, so
Your deed,
it's grantee.
you are the current owner of your property, are you not?
Yes.
Don't talk. You are the current owner of your property, correct?
Yes.
And you got that from somebody else.
Yeah.
Well, that somebody else was the grantor.
Yeah.
You are the one who received the deed. That makes you the grantee.
I doubt myself, but I felt that way. I say grantee. I'm like,
It's okay. I got agents out there. I ask them that question, at least 80% of them get it wrong. Here's why. Because they were told in FREC1 they had to learn to speak the language. And I guess they thought that was pure bullshit, and so they didn't bother. And now, you think I'm hostile now? They pull that stuff out in training. That means that they're gonna pull that stuff in front of a buyer or seller or another agent and get the company in trouble. So I get seriously hostile seriously quick. This is a very litigious business. And they'll turn you in a heartbeat and not think twice about it. So you have to learn to speak the language. Because you know what? If you screw that up, you're gonna have the wrong owner on your listing agreement.
yeah.
Because you're gonna go into the public records and pull up the deed to figure out who the owner is I'm gonna put on my listing agreement. And if you pull the grantor, we're gonna have a problem. Because the grantor doesn't have the ability to do anything with that property. Why? They are not the current owner. The grantee is the current owner. Don't believe me, go to the property appraiser and look up your deed. Or Or I'm sure you have it with your important papers, wherever they are.
In the cloud. In the cloud.
In the cloud? Okay, so pull it out of the cloud.
From anyone's.
Yep. When you see these, we talked about lessor and lessee, we talked about now grantor and grantee. The OR is the person who gives the paper. EE is the person that receives the paper. See, if you do it money-wise, you reverse them. Because in a sales situation, the buyer gives the money to the seller. But that has nothing to do with grantor and grantee. These names are based upon the documents. And we know that the current owner has to sign a new deed showing themselves as the previous owner, which is the grantor, and you as the present, as the future owner, the grantee. This represents the transfer of documents, not the transfer of money. Because if the documents aren't right, money ain't showing up. All right. No. Yeah, we got here.
He's got here. He's got here.
I want you to read the first paragraph on this deed.
Can you give us any? Oh, no, never mind.
This looks boring. Quick claim deed.
First paragraph.
You know baseball?
I'm in sports in general. Not like they used to be. Too much other shit.
Okay, I gotta see.
Just the first paragraph.
What are we looking for?
Nothing, we're reading.
Whenever I ask you, as soon as you read it. Now, we have a grantor and a grantee who are the same person. This obviously was not a sales transaction. This was somebody setting up their estate. The original owner, Phyllis, gave herself a life estate and named, I'll take a wild guess, probably the two daughters
And
as the remainderment. Now, my question to you is this. Do we need the two sisters' signature on their name and their signature on our listing agreement?
Yes, we do.
Yes.
You do it.
Yes.
Where did it say?
Yes.
A life estate.
No.
Okay, we got a vote.
Okay, hold on,
How many of you say that the two remaindermen would have to be added to the transaction? How many of you say it would just be Phyllis? Now, I want everybody, you got your highlighter?
Yeah.
Okay, get ready. I want to go to line 3 where it says Phyllis Lease. I start highlighting. A single woman with that address for a life estate without liability for waste and with full power and authority in said life tenant to sell, convey, mortgage, lease, or otherwise manage and dispose of the property described herein in fee simple, with or without consideration, without the joinder of the remainderment, and with all power and authority to retain any and all proceeds. And if there's any shit left over when I die, they all get it.
Oh, yeah, so she can.
Now, anybody that told me that you had to have the two remaindermen means you didn't read the damn paragraph. Because it is crystal clear. It says without the joinder.
Yeah.
Or maybe it's those big fancy words we have trouble with. Does somebody know what a joinder is? It's not marijuana.
What is without liability for waste? What is that?
I'm going to bring that up. This is a Lady Bird deed. It is an enhanced life estate. Because if you go back to your notes, what I just read to you and had you highlight is not part of the life estate that we talked about in the book. This is the one you will see more often in real life. It's called a Lady Bird deed, and the reason for that is the first person in the United States to be given property under this type of deed was Lady Bird Johnson. You will see a lot of these in your 55+ communities.
Okay, in English, what was the rationale for doing it?
What was the rationale?
Yeah, what is she trying to accomplish?
Well, number one, she knows that she didn't have to worry about whether the girls are going to get the property if she dies. And number two, if she decides to sell it, she still can,
Without having to.
without having their permission.
So just that.
A regular life estate, the two of them would have had to be willing to sign.
If she owns it, why is she going through all this other stuff?
Just to name
But she wants to
beneficiaries?
leave it for them. when-
Uncle Sam, in taxation, when you die,
Just do good pay tax.
you pay a whole lot
You write the
less.
check as you're in the casket.
It's also to designate who they want to receive the property, so we don't have to worry about probate.
If
all
she
this
had a
other
will,
stuff.
wouldn't that be in the will?
Well, will may still have to be probated.
I think she should have in trouble.
So this even,
So it is best to have a trust in the will then.
yes.
To seek an attorney.
You understand that that is not a question I can answer? Not from a legal standpoint, but from a practical standpoint. I don't know enough about how your estate is set up and what you're trying to accomplish with this in order to advise you to use a trust or use something like this. But see, understand a trust is not just about a piece of property.
Well, I understand, it's a.
This
whole-
is
it's
just
a-
about a piece of property. It's just another form of ownership. It's a modified life estate.
Yeah, that gives you
See, but it's not, it's
power to
It's
sell.
not-
Yeah.
it isn't created to do what a trust is created.
Are there another type of, ways to do the other things differently as well? Because this is.
No.
This is the only one?
Yeah. For now.
I thought it was just
You did that?
larger wording additionally to what we got.
No.
So this must be accepted by the, what, an act or what? To add this type of,
The parties to it, the deed.
yeah, I know.
Yeah, now, here's something you gotta realize. This is not a sales transaction. So if you're thinking about it being a sales transaction, this is not a sales transaction. See, something you gotta get in your brain is that the transfer of title doesn't occur just because the property is bought or sold. This wasn't created, and the one I described, with the people I worked with, wasn't created to help them buy or sell it. It was to help them set up their estate, to figure out, because they wanted to make sure when Dad died, nobody else in the family come screeching in there and dump him out in the street.
So I have an example. For example, I own my house only in my name, and I want to have my two girls have the house. So I can do this, attached to my title.
Yes. Now,
and it's
see,
protected?
you would want to do that one, not the one from the book.
No, no.
Because this one still gives you the ability to, and then, you know, when you're dead and gone, if anything's left that you haven't gotten rid of,
And this is revocable anytime?
yeah.
Instructions, legal instructions.
But our time in the transaction, when I'm dealing with my customer, and he or she is bringing this up, should I add this statement into the underwriting or to do the deed of the property?
That is a question for the attorney or title company, not for you.
Okay, so I don't have to do.
I am teaching you to speak the language.
Okay.
Not because you're gonna use the language, because you have to communicate with people that do speak the language.
So the customer.
You have to be able to speak to lenders, you have to be able to speak to underwriters, you need to be able to speak to surveyors, to appraisers, you have to be able to speak their language.
So the customer should address this to the title company in the moment of the
Well, what do you
closing?
think? Do you think I should tackle something like this, or do you think that should be the attorney or title company?
I guess the title company.
But I'm gonna make the phone call. It's like when I found out that deal, that they weren't gonna let the husband and wife onto the contract with the father, I went to them and explained what was going on, because I knew pretty much that we could do something like this. I don't think we did this later. I can't remember now.
The banks will do a later.
And the only reason it's called Lady Bird is because Lady Bird Johnson was the first person to ever be given property under this type of ownership.
So as a buyer, this has to be addressed with the title company or your attorney?
Well, there's nothing to address. Maybe.
I mean, set up.
Yeah.
I mean, if you want that your deed says that, you have to address.
The odds are you're probably not going to set up your initial purchase this way.
Why not?
Because there's too many things going on here that you have to deal with in the middle of a sales transaction.
If it is your primary home that is homestead, this basically, it will reflect the deed.
Yeah, my deed shows my name and my wife's name, and then comma his wife.
And simultaneously prepare.
Why did they put his wife there?
Once they record.
Which pisses her off. She says it sounds like his dog.
Because isn't that the language that was used back, like you said, in the.
Because they're married.
But then, oh.
It told me that this is an estate by the entireties.
Yeah.
Because if they give me a husband and wife, and it shows fee simple, which it does on my deed, then it's an estate and settlement. I'm sorry, estate and settlement. Estate by the entireties. Which is ownership by husband and wife. But if his wife wasn't there, we don't know for sure what they are. Could be brother and sister. Could be two people just happen to have the last name of Doyle. But the point being is, what's the best way for someone to set up the ownership of the property? Not a question I'm gonna answer. However, I know who can give me the answer. And a lot of times when agents call in and ask me about things, I call the title company. Or I direct them immediately to the title company. Now, one maybe because I'm too busy, and I realize this isn't something I'm gonna make final decision on anyhow.
Also, they're gonna be answering questions about which figure is the best regarding taxes, for instance.
Well, that's something you need to talk to your tax person about.
Not
See-
not the attorney of the title company.
No, not unless it's specialty is taxes. If I'm looking at, the tax issues, then I need to bring my accountant.
If they ask, then I will not tell them, ask their accountant or something like that.
Anytime they ask you a question that you know is a question where they're asking you something about the legality of something, which is what we're doing here, I'm not gonna answer that question. And it's not that I'm not gonna answer the question. It's that if I'm gonna answer it, I'm gonna talk to whichever expert, whichever resource is what I want to go to. That's what I'm talking about when you're with a company that has those kinds of resources. There's not any question you can't get an answer to in a relatively quick period of time. And the problem of it is, people, it's not black and white. We always like to make it black and white, and guess what? It's not black and white. And what's gonna work in one situation may not work in the other. And I don't try to keep up with all this stuff, because this stuff changes. That's what I have the resources for. My objective here is to get you aware of everything that's going on here. To be able to walk out the door and have all this down, yeah, right, maybe in your next life. I've been doing this for 40 years. I learn something new every day.
Yeah, of course.
That's what I find out fascinating about the business. I have never been bored. Aggravated, but never bored. I mean, just the questions I get in class. A lot of times, I don't know the answer to them. Bored is not something that's in Pittsburgh. All right, guys.
I have a question.
Here we go. Yes, no, wait 1 second.
Is the bottom line facetious?
No, because love and affection is a type of consideration.
Yeah, it's in one of the cards.
And this is, now I know this is between mom and sister. Because of the statement at the bottom of the page. But love and affection is a form of valuable consideration, good consideration, but it is a form of consideration. But see, again, this was not a deed used at a close.
No, I'm a tech, technology.
Transfer over.